Good afternoon, everyone. Get ready to start.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, we have ASG Alicia Fawcett joining us today. She is recently come to us from the DeKalb County Solicitor General's office, and she'll be handling 5 of our cases today.
Great. Welcome aboard. I think we introduced her yesterday.
Okay.
Or we tried to anyway. We thought she was an imposter. She was like, who is that? So we welcomed her yesterday, and you had another person too, I think, on yesterday.
We did. Miss Danielle Russell. She's going to be one of our supervisors.
Okay, great. Welcome aboard. All right. Has everyone been interviewed, I hope, today? On PD side?
Yes, I have interviewed everyone. Position 6 is a waiver, Your Honor, and I am requesting a breakout for position, or actually it's on the add-on.
Oh, do we have an add-on? I didn't see one. Hold on.
Yes.
It just came through, Your Honor.
Oh, okay.
No,
Mr. Jordan, forward that to me. I hope it is a one add-on. Is it?
No, but they were cases that were originally on the jail calendar. We just had a bit of a delay in getting them filed down.
Okay.
And I just forwarded you that calendar.
Thank you.
And for position 7, Ms. Kennedy, the jail told me that she was in medical, and so I don't know if she's able to be here today. But if she is, I would need a breakout to speak with her, or I would need to have them call me.
Deputies, is that Sylvester Kennedy?
Mm-hmm.
Courtroom 2.
We don't have that person. The person's in a wheelchair. We have to get someone to go to medical.
Okay.
And which case is on the add-on calendar that needs to have a breakout?
I am requesting a breakout for position 1, and I mean, I'm fine with waiving sounding for position 4 or a breakout, just be out of respect for the complaining witness's privacy.
Waiving sounding on position 4 or waiving sounding on position
4?
Not sure what the privacy issue is there.
Well, if you read I think you're going to read the warrant or the affidavit for arrest. So,
okay.
All right, we'll get going then. All right, everyone, we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, or a possible plea offer if one has been made by the state at this juncture. Mr. Jordan, what is our SAP reset date?
It's December the 19th.
December 19th. All right, that's your SAP date, 12/19. I want to remind the everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to also remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to representation at this time, and you should know who your attorneys are by now and spoken to them. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The state is here and they're listening, so follow the lead of your attorney. All right, who do we have first, deputies?
Position number 8, Ms. Moore.
Okay. This is 24 CR 008000F. Shiva Moore, charged with 1 count of criminal trespass. Pretrial.
This defendant's last arrest was November the 16th, 2024, out of Atlanta for theft by shoplifting. It appears that they're on probation for that case. The probation case number is 24 CR 011002. They have a total of 21 arrest cycles. Felony conviction in 2017 for criminal attempt to commit a felony. They received first offender treatment on that, and it was sealed in 2022. There's a 2022 misdemeanor conviction for driving while license suspended or revoked. 2013 DUI and endangering a child while DUI. And there are 3 theft by shoplifting misdemeanor convictions, one in 2002, 2009, and 2012. The recommendation from pretrial is a UJR level 2. Nothing further to report.
All right, state.
Yes, Your Honor. This incident happened December 6, 2024. Officers met with Joe Malanda at Court Lindbergh at 741 Morosco Drive in Atlanta. Mr. Malanda was an employee at Court Lindbergh, and he stated he had found the defendant in a vacant unit that they were cleaning out. She had been previously trespassed from that location, and the defendant was woken up and detained by the police from the bedroom closet she was sleeping inside of in that vacant apartment. As you've heard, this is the defendant's 22nd arrest. Her most recent conviction, as you've already heard, was November 19th of 2024 for a theft by shoplifting in Atlanta Municipal Court, which was approximately less than 3 weeks ago that she had her most recent conviction. She received 12 months served 10 days with a stay away from 2539 Piedmont Road on that case, and that is still an open case for which she's on probation, and within 3 weeks she's already violated. She also has an FTA from 2017 and multiple probation violations from 2017 to 2022. The state would ask for a $1,000 surety bond. Stay away from Court Lindbergh at 741 Morosco Drive in Atlanta. No alcohol, drugs, or weapons. That's all for the state.
All right, PDs.
This is my case, Your Honor, and Ms. Moore is 48 years old. Although she does not have a physical address, she does have a good mailing address where she can receive court notices from. She has lots of ties to the community. She was born in Georgia, does have adult children that all live in the area. She is currently residentially challenged. It was freezing. She went into a vacant apartment because she was freezing. It's been extremely cold here, and that is what we discussed. She does have some health issues. She is asking for a signature bond in this case. Doesn't sound like there was any damage. And again, she does have a mailing address, so she would be able to get court notices.
And again, the UJR is just a recommendation. I'm not impressed with the history. So I'm going to go with the 1,000 surety bond. And with that surety bond, no drugs, alcohol, weapons, or guns while on bond. Stay away from that 741 Morosco Drive, the Court Lindbergh. Don't go back to that complex. And I think that's all the state asked for. We didn't ask about any contact, right?
No, Your Honor, we didn't ask for no further contact.
All right, that's it. 1,000 surety.
that's what.
Position number 13, Ms. Reed.
Okay. This is 24 CR 008007A, Jalen Reed, charged with one count of simple battery, second count of disorderly conduct, and third count of criminal trespass and damage to property. Retrial.
The last arrest was December the 12th, 2018, out of Dunwoody for driving while license suspended or revoked. They have a total of 9 arrest cycles. Felony conviction in 2015 for ID theft and printing, executing, negotiating checks, knowing info is fictitious. They received first offender treatment on that. It was sealed in 2018. There's a 2016 felony conviction for theft by receiving and burglary. The recommendation from pretrial, with the exception of the restricted charges, is a level 3, nothing further.
All
Good
right.
afternoon. Good afternoon, Judge. We also have a 2019 conviction for disorderly conduct. This incident happened yesterday at the Yard House restaurant at Atlantic Station, 261 19th Street. The defendant entered the restaurant and became upset over a seating issue. She started acting irate, yelling aggressively. She began a verbal dispute with one of the Yard House employees named Deontay Binion that eventually escalated into her spitting on that employee. The warrant states that she caused a fight as well. The defendant continued to act violently in the restaurant, began throwing plates, glasses, and also threw a server kiosk and damaged all those items. And given her conviction within the last 5 years of a similar nature, Your Honor, we are requesting a surety bond, $1,000 on each count, no further contact with Deontay Binion, stay away from the Yard House restaurant. We're also asking the defendant enroll in anger management courses, no weapons, drugs, or alcohol. And if you can sound for Mr. Binion, Judge, thank you.
All right. Mr. Deontay Binion. Mr. Binion. Don't think he's on. Next. PD Bronstein.
Yes, Your Honor. And just to clarify, this is position 13, Ms. Reed.
Correct.
Okay. And so Ms. Reed is 28 years old. She was born and raised in Atlanta. All of her family is in the area. She has several ties with communities. She currently is a student at Georgia State. She's set to graduate in spring of 2026, and she is studying marketing and finance. She also works part-time while going to school. As far as this case goes, I know we're not trying the case right now. However, I did look at Mr. Binion's. Basically, it sounded as if she was defending herself, and I did look at the complaining witnesses' criminal history and current pending cases, and that is highly concerning and very violent. And that really did give credence to what Ms. Reed was telling me about how she was defending herself. She said she was hit in the head with a chair and that she has a knot on her head. And 2 men aggressively walking towards her. She said she did not intend to do anything to any servers. She was just trying to defend herself against the men who were kicking her out of her chair. She tried to get back into her chair, kicked her, all of that. Considering all of this, Your Honor, we would ask that the court do a signature bond for Ms. Reed.
All right. I don't believe there was any violence or batteries in her history. Is that correct?
That's correct, Your Honor. She does have a disorderly conduct conviction from 2019, so I would classify that as a violent conviction, but there's no batteries or aggravated assaults or anything like that in her history.
All right. Looks like she's in her second year at Georgia State.
Yes, looks like you said graduate spring 2026, right, Ms. Reed? She shook her head, yes.
Okay. All right. I will give her a signature bond through pretrial for $3,000, $1,000 on each of the charges. And I think did they have her at a level 3?
Yes, Your Honor.
All right, I'll keep it at a level 3. 1,000 on each, and then no drugs, alcohol, weapons, or guns while on bond. And to stay away from the Yard House Restaurant at Atlantic Station.
And Your Honor, since you're ordering it through pretrial, we don't request anger awareness.
All right, 2-day anger awareness course. And then is there a no further contact with Deontay Binion?
Yes, Your Honor.
Okay. No further contact with him. And that should do
And
it.
she does not know him, so that is perfectly fine.
All right, good. All right. That should be it. Any questions?
Judge Mincy, did you say 2-day anger awareness?
Yes.
Okay, thank you.
And Your Honor, we would just request no weapons, drugs, or alcohol. I can't recall if you said that. Apologize.
I don't either. It's Saturday. No drugs, alcohol, weapons, or guns while on bond.
Position 2, Ms. Benton.
This is 24 CR 008014E. Harita Benton, charged of 1 count of simple assault, a 2nd account of theft by taking. Pretrial.
This defendant does not have any history to report at this time and is recommended, with the exception of the restricted charges, recommended for UJR through the jail.
All right. State.
Your Honor, this incident took place on December 6th. Officers responded to a 911 call from the Tim Morgan catering business, 1465 Chattahoochee Avenue, regarding a dispute with a weapon. The victim in this case is Timothy Morgan. He's the business owner there. He stated that at approximately 8 p.m., the defendant arrived to his business to return her uniform. She was a former employee. She was in the process of being fired for not showing up to work. When she came to return her uniform, she became irate. An argument began, and at some point during the argument, the defendant brandished her firearm. The victim told officers that he was scared the defendant was going to use the firearm. Of course, there were also 2 other witnesses on the scene that saw this altercation. One of them has actually been shot before, and so when the defendant brandished her firearm, 2 other witnesses intervened and lunged in between the defendant and the victim and had to hold the defendant back to prevent her from using her firearm. The defendant initially fled the scene. The victim had a cell phone that was sitting on the counter at the location, and he advised that the defendant took his cell phone prior to fleeing the scene. She did return to the scene to speak with police. She was Mirandized. She did admit that she brandished her firearm. The police seized the firearm. She did deny taking the cell phone, but the cell phone was never recovered. And Your Honor, although this is her first arrest, this is a dispute involving a firearm, and there's a dangerousness factor here. So we are requesting a $10,000 surety bond, $9,000 on the simple assault, and $1,000 on the theft. Absolutely no contact with Mr. Timothy Morgan. Stay away from his business at 1465 Chattahoochee Avenue. An anger management course, no weapons, drugs, or alcohol. And if Your Honor can sound for Mr. Morgan, nothing further.
Timothy Morgan. Timothy Morgan. Nope. All right. PD Atai.
Yes, Your Honor. And just to clarify, she is charged with a simple assault and the theft by taking for the phone, not brandishing a firearm. She is 47 years old, and this is her very first arrest, Your Honor. She has absolutely no criminal history. She's lived in Georgia all her life. She is married, owns a home in Snellville, Georgia, and she was, until recently, working as a caterer. She has two children, minor children at home, 17 and 14 years old. She lives with them and her husband. She is a lawful weapons carrier. She denies that she brandished a firearm at all. The warrant states that it was in her holster. And apparently there were two other people who said that they had to grab her to prevent her from getting the firearm. If the firearm is secured in her holster, Your Honor, she wasn't committing any crime. And, you know, flashing a firearm while it's in a holster is not a crime. This is her very first arrest. She's 47 years old, a law-abiding citizen, carries a weapon legally. And I would ask for a signature bond through, it's a restricted offense, but I would ask for a signature bond through pretrial services at level 1 for her.
And Your Honor, threatening someone with a firearm is absolutely a crime.
She didn't threaten
And
anyone with a firearm.
we can argue those facts at trial, Ms. Atai.
Okay, but just, she's charged with simple assault, so she's not charged with threatening anybody with a firearm.
That's what simple assault is. It is threatening someone.
No, it means that he was
Means
scared.
that-
He was.
Yes. You
Yeah.
committed an
He was
act
I
that
don't
put
think
them in
it's-
reasonable fear
I
for
don't-
their safety.
I don't think it's reasonable to be fearful of a weapon in a holster in this country because it's legal.
Well, we'll have to agree
If
to
you're
disagree
afraid
on
of a
that.
weapon in a holster, you got to move somewhere else.
Well, when you threaten someone in the middle of a dispute with your firearm, like you're going to use it, that's not, you're mischaracterizing it, Ms. Atai, and
If
we
she
can argue
has a
those facts at
weapon in
trial.
a holster, that is not a simple assault.
All right, ladies. I'm going to so with the simple assault, I guess I'm giving a split bond. Simple assault would be uh 5,000 surety, and then the theft by taking 2,000 SOB. I guess SOB jail. And then that's a total of 7 split, 5 surety and 2,000 SOB jail for the theft by taking.
Your Honor,
And-
just a reminder, under SB 63, theft by taking is one of the qualifying offenses.
I thought they told us there was some error last week.
Oh, I can go and double check.
I don't remember.
It was my understanding that there had to be a previous conviction for a theft by taking for a theft by taking to be a restricted charge, Your Honor, but let me look.
And that's correct. And she has absolutely no criminal history.
I think that's what we determined a few days ago, maybe on the theft.
However, Judge, if it does go through pretrial, then Your Honor could order anger awareness, which we of course would support in the fact pattern that you heard today.
Well, Your Honor, I think that the order that you initially said would be correct for the theft by taking the $2,000 SOB through the jail. She doesn't have a previous theft by taking conviction. And Your Honor, I mean, if you want to send it all through pretrial at level 1, I would not object to that. It is her very first arrest. She's 47 years old.
Okay, let me change that and take it through pretrial. Sorry, Mr. Jordan, I'm gonna do a 7,000 SOB pretrial. I'm going to have her to take the 2-day anger awareness. So that'll be 5,000 on simple assault, 2,000 on theft, total of 7 SOB pretrial, 2-day anger awareness, no drugs, alcohol, weapons, or guns while on bond. Stay away from 1465 Chattahoochee Avenue and no further contact with Timothy Morgan. Anything else?
Your Honor, the
Nothing.
state would just object on the record to a signature bond in this case. Nothing further.
All right.
We can do, position number 1 over at Alpharetta Jail.
Okay. This is 24 CR 00800131J. Soliman Abdolia. And I'm sorry if I'm mispronouncing the name. This is 1 count of criminal trespass, 2nd count of theft by shoplifting, pretrial.
The last arrest for this defendant was June 15th, 2024 out of Fulton County for an FTA. They have an open case in Superior Court for possession of heroin, possession of cocaine, and driving while license suspended. That case number is 18 SC 157550. They have a total of 12 arrest cycles in Georgia. The recommendation from pretrial is a UJR level 3, nothing further.
All right, state.
Well, yes, Judge, this incident took place on December 6th at the Walmart. Incident location is 970 Mansell Road in Roswell. The defendant had been issued a criminal trespass warning back on May 23rd, 2023. He returned back to the location yesterday, and he was checking out with a cart full of items and failed to scan about $40.72 worth of merchandise, specifically 2 cans of spray paint, sockets, and a phone case. When he was confronted by loss prevention after passing all points of sale, the defendant did admit to loss prevention that he did not have the money to purchase the extra $40 worth of merchandise and was attempting to shoplift it. Or he did shoplift it because he passed all points of sale. And Your Honor, given his open felony matter and he has several failure to appears in his arrest history, we're requesting a $1,000 surety. That'd be $500 each count. Stay away from Walmart, no weapons, drugs, or alcohol.
Okay. Then the state is requested to stay away from the Walmart, correct?
Yes, Your Honor.
All right. PD Bronstein.
Yes, Your Honor. Is 45 years old, has lived in the Atlanta area since 2014 with his wife and 2 children, a 6-year-old son and 15-year-old daughter. I first want to address the criminal trespass issue. According to the warrant, it looks like there was a warning that was issued with no end date. I've never seen such a warning. He did go to court to resolve the criminal trespass case. He didn't think that was still ongoing. I think that's a reasonable assumption that he made. He typically does work as a mechanic. However, he injured himself and has been, since he works with his hands, he's been unable to work recently. That is why he was low on funds. He was trying to finish a job so that he could try to get back on his feet. We are asking that the court grant him a signature bond in this case.
And PD Bronstein, are you saying that he had a previous criminal trespass arrest at this Walmart in 2023? that he thought he resolved and was no
He-
longer under warning?
He thought that the criminal trespass warning was over. I've personally never seen one that did not have an end date.
Okay, so you're not saying that he was previously arrested. You're just saying that there was no expiration date and he thought that it expired, even
Yeah,
though he
I'm
was
sorry if
not.
I said something else, I misspoke.
I'm just trying to make myself clear. Okay, Your Honor. So just there's no requirement that a criminal trespass warning have an expiration date. The law just requires that the defendant be put on notice exactly where he's not permitted to enter.
I wasn't arguing the charge, I was just explaining.
All right. And tell me again, the state's recommendation.
A 1,000 surety, Your Honor, total. So it'd be 500 each count. Stay away from Walmart. No weapons, drugs, or alcohol.
All right. And Miss Bronstein, you were recommending?
A signature bond through pretrial, I believe, level 3.
I will go ahead and give the $1,000 surety bond. 500 on each. Stay away from the Walmart and Mansell Road. No drugs, alcohol, weapons, or guns while on bond. That's it. Anything else?
No, Your Honor.
You can go to ACDC.
Good afternoon, Judge. This is going to be position number 16, solo.
Okay.
That's Ms. McLeod's case.
Your Honor, there are 2 co-defendants in that case. If we could bring them up as well. The 2 co-defendants to this case are Robert Coleman and Leroy Cooper, if they're in courtroom 2.
They're on their way up.
Okay.
All right. So we're doing 16.
Coleman and Cooper are positions, 16 is solo. Coleman and Cooper are going to be positions 4 and 3.
Okay. Which
And
are
the
we?
fact pattern is the same for all 3.
Oh, okay. For solo and 3 and 4.
Yes.
Okay.
So we can start with solo, but I just wanted you to know they're co-defendants and the fact pattern is going to be the exact same on all 3.
Okay.
And Judge, so we only have one conflict attorney. I wasn't able to get a second one for Coleman.
Oh, that's right. We just have this filed. So the other one would need a conflict defender. You have any other friends turning the file? The call.
Oh, Your Honor, it's Saturday. My friends tend to be on the golf course or somewhere else.
Right. They're somewhere enjoying their Saturday. I get it. One of them, is he willing to go pro se or not?
So Miss McLeod is representing solo. Coleman is the one we don't have an attorney for.
Okay. Mr. Coleman.
Mr. Colvin said he spoke to someone, so I don't know.
Oh, did he?
Well, he may have spoken to Miss McLeod earlier, but at the time, I don't think anyone realized.
Mr. Cooper was the person who spoke to me, but in the course of speaking with him, I realized that he was a conflict for me because I had already spoken with Miss Sola.
Okay. So Mr. Cooper, are you willing to represent yourself or you want to wait till tomorrow? I mean, to Monday to get your conflict attorney?
No, ma'am, I'd rather represent myself.
Okay. All right. We'll start with,
Miss Sola,
mhm.
ladies first.
All right,
There
Your
we
Honor.
go. All right,
Um,
this is 24 CR 008004C La Rosa Solo, charge of 1 count of criminal trespass. Pretrial.
The last arrest for this defendant was July the 30th, 2009, out of South Carolina for forgery. They have 5 arrest cycles in South Carolina. There was misdemeanor convictions in 2007 and 2009 for forgery. The recommendation from pretrial is a UJR level 1, nothing further.
All right.
This incident, Your Honor, happened on December 5th, 2024. Officers responded to Polaris at East Point, located at 3072 Washington Road, apartment B5. That was a vacant apartment at that location. Employee Maurice Hicks located these 3 defendants trespassing in the vacant apartment. Mr. Cooper admitted to entering around 8 a.m. Mr. Coleman admitted to entering the night before, and Ms. Solo admitted to entering at 6 a.m. The police were called at around 10 a.m. Hickman stated he made contact with the defendants the night before on December 4th and told them to leave the premises. Miss Solo is a multi-state offender, as you've heard. She has 1 arrest in Georgia, 9 cycles in South Carolina. Her most recent conviction was that 2009 forgery in South Carolina. The state's recommendation is to reduce the $3,000 surety bond to a $1,000 signature bond through pretrial services level 1, with a stay away from the Polaris at East Point, located at the address of 3072 Washington Road, as well as no alcohol, drugs, or weapons, no further contact with Maurice Hickman. That's all for the state.
All right.
Your Honor, I have no objection. We have no objection to the signature bond. I just wanted to say that my client has not had any kind of arrest since 2009, I believe was her last arrest. She tells me she's a widow. She became a widow last year. She's 59 years old, and she's fallen on hard times. And it was a very cold night. She didn't have anywhere to stay. Nothing further, Your Honor.
Okay. I will order a $1,500 signature bond through pretrial for that 1 count of criminal trespass. We're gonna order her to stay away from, I'm assuming she does not live at this East Point location.
It does not, Your Honor.
No, Your Honor, this was a vacant apartment that she was
Vacant.
staying in.
Okay. All right, so to stay away from that whole complex. And it's called what, the Laris at East Point, did you say?
It's called Polaris,
Polaris.
Polaris at East Point.
Okay, Laris at East Point. Stay away from that whole complex since you don't live there. I'll put her at a level 1 with pretrial and no drugs, alcohol, weapons, or guns while on bond. And that should be it for Miss Solo.
We
Thank
can
you,
do
Your Honor.
we can do number 3, Mr. Coleman.
Okay. Mr. Coleman,
And,
your case is,
I'm sorry, Your Honor. I actually am representing Mr. Coleman. There's another Coleman. I think I got a little bit, there was a little miscommunication with the request for conflict attorneys. Actually, I think Cooper has not been interviewed. And he would be the one who needs the other conflict attorney.
I think he said he
That
was
is
gonna go
correct.
forward
Mr.
and
Cooper, I
represent
spoke to
himself.
him briefly, Your Honor. I realized that there was a conflict.
Gotcha. All right, with the Coleman case, at the 1 count of criminal trespass, pretrial,
The last arrest for this defendant was June the 13th, 2024 out of Fulton County for an FTA. Felony conviction in 1994 CWAC charge, 2006 passing bad checks. Misdemeanor conviction in 2019 for criminal trespass. They have a total of 16 arrest cycles, and that's out of Georgia and Missouri. Nothing further to report.
All right. And I've got the facts state.
Yes, Your Honor. So Mr. Coleman is a multi-state offender with 10 cycles in Georgia, 6 cycles in Missouri. His actual last conviction was 24 CR 003808. That was on August 6, 2024, which was about 4 months ago. Judge Morrow sentenced him to 12 months, served 4 days, credit for time served 2 days, suspended, and there was an order to stay away from the Polaris apartments, which are these apartments that he was back in. The defendant also has an FTA in the last 5 years, which stems from that 24 CR 003808A case. He did not appear in court and was then rearrested and pled out to the criminal trespass, and the failure to appear was null prost. The bond is currently set at $3,000 surety bond. We are agreeing to a reduction to a $1,500 surety bond, and we are asking for a stay away again from Polaris Apartments located at 3072 Washington Road, Apartment B5. We're also asking for no further contact with Maurice Hickman, no alcohol, drugs, or weapons. That's all for the state.
Okay.
Your Honor, my client is 57 years old. He has lived in Georgia for the last 5 years. He does have family here in Dallas, Georgia. He did recently separate from his wife and has been residentially challenged since that time. I know that he has that more recent, I think it's a criminal trespass. And then I think his last arrest was June for an FTA. He has been residentially challenged, but he has a mailbox now where he receives mail, and he does hope to reconcile with his wife and move back home to Dallas, Georgia. Your Honor, it has been cold. I don't think that any harm was done. I understand that he is charged with criminal trespass. He says that somebody, and there was no forced entry or anything into the apartments. He tells me that somebody allowed him to stay there, but he didn't want to get them in trouble, somebody who works there, Your Honor. So I would ask for a $1,500 signature bond through pretrial services. He is recommended UJR level 2. I think most of his arrest history, other than the more recent criminal trespass, is is very old. I heard 2006. So I would ask the same, that the co-defendant, $1,500 signature bond.
And Your Honor, I just want to point out that pretrial services wasn't even aware of his most recent conviction from 4 months ago. And the difference between Mr. Coleman and Ms. Solo is that Mr. Coleman has a recent conviction for criminal trespass from the same location he was at on December 5th when this incident happened.
Okay. So right now he's set at 3,000 surety,
Yes, Your Honor.
and that's been since December the 5th. I will give the $1,500 surety bond. And stay away from the Polaris at East Point, I believe is the name of it. No further contact with Maurice. Was that Hickman?
Yes, Your Honor.
No further contact with him. You must stay over 200 yards away from him. No drugs, alcohol, weapons, or guns while on bond. And let's see, I think, is that it? No drugs, alcohol, weapons, or guns while on bond? Anything else I need to do? And are we saying he should have no further contact with the co-defendants or not?
We're not asking for no further contact with the co-defendants, Your Honor.
Okay. Then that should be it for Mr. Coleman. 1,500 surety.
Number 4, Cooper.
This is 24 CR 008006G. Leroy Cooper charged with 1 count of criminal trespass. Pre-trial.
The last arrest was January 23rd, 2024, out of Fulton County for battery family violence. That case is open under 24 CR 000492G. There's felony conviction in 2010 for possession of cocaine, 2008 burglary, misdemeanor conviction in 2007 and 2012 for criminal trespass. Nothing further to report.
Okay.
Your Honor, on Mr. Cooper's case, he had a conviction for criminal trespass in DeKalb in 2012. Most notably, that newest case from January of 2024, where he received a $2,500 signature bond from Your Honor on January 26th of 2024. So he is currently on bond and has violated the bond of, one of the requirements is that you cannot commit a new offense, which he has now violated with this offense. He also has a $3,000 surety bond. We're agreeing to reduce that to a $1,500 surety bond with the same conditions as Mr. Coleman and Ms. Solo, which is that they stay away from the Polaris in East Point, no further contact with Maurice Hickman, and no alcohol, drugs, or weapons. That's all for the state.
Okay. Which,
this defendant is the unrepresented defendant, Your
oh,
Honor.
that's right. And
So
so,
I'm not sure if you identified whether he wanted to proceed pro se. I know you did with Mr. Coleman before we realized he had counsel, but I
Right.
don't know if you did with Mr.
Mr.
Cooper.
Cooper, right. Mr. Cooper, are you willing to go forward and represent yourself?
Yes, ma'am, I am.
All right, you understand there could be consequences to representing yourself. You
Well,
ready to take that risk?
Yes, I'm just telling the truth, Your Honor.
Okay, well, I'm not gonna go through a lot of the facts with you. I just want to know, how old are you?
I'm 65, Your Honor.
All right, 65. You have a little history here on your criminal record. Do you work or anything? Are you retired?
I'm retired, Your Honor.
Retired? Okay. And so do you need to have a social worker? I guess you can't have a social worker visit you because you're not part of their plan. I was going to ask you a question I normally ask, but I can't. Retired, you reside somewhere?
I didn't understand, Your Honor, what you said.
Do you live, where do you live?
I I live with a friend of mine, Your Honor. And I was just trying to help the young lady out. That day I got caught in the house.
All right. I'm going to order a $1,000 surety bond on this criminal trespass. No drugs, alcohol, weapons, or guns while on bond. And no further contact with Maurice Hickman. And stay away from the Polaris at East Point, the whole apartment complex, because you do not live there. Is that correct?
That's correct, ma'am.
Okay. And I think, is there anything else I need to take up?
That's all for the state, Your Honor.
All right, 1,000 surety.
Judge, next we have position number 5, Ms. Flan. But before we proceed with position number 5, I have a quick announcement for position number 6, Ms. Howard. She waived her appearance.
Okay. I
And this
have
is
that.
position number 5, Ms. Bland.
All right. 24 CR 008003B. Advana, is it Flan or Flan?
Flan.
Sorry to mispronounce it. Charged with 1 count of simple battery family violence, a 2nd count of battery family violence. Pretrial.
There's no history to report for this defendant at this time.
All right, state.
Yes, Your Honor. This happened on December 5th, 2024. The defendant was residing with Keenan Webb at 1133 Huff Road Northwest in Atlanta. According to Mr. Webb, the defendant entered the bedroom while he was putting their child to bed and grabbed him by his arms, which left visible scratches. The officers were able to observe those scratches and did notate them in the warrant. We had an opportunity to speak with Mr. Webb. He stated that he and the defendant are not in a relationship. They do live at the incident location together and they share 1 child. He stated that the defendant was upset by the way he was talking to their son, and she came into the room and began grabbing him and leaving scratches on his arms. He stated, although he does not wish to move forward with the charges, we do have some concerns since there's been less than 48 hours since this incident happened. We do ask that in family violence cases that cooling time is taken into account. Mr. Webb did state he is planning to move out of the residence and he will be on Zoom and is okay with her returning back to the residence. We are asking for a $3,000 signature bond through pretrial services level 2. That is due to the fact this is her first arrest. $2,000 on the battery, $1,000 on the simple battery, no further violent contact with Keenan Webb. We are also asking for family violence intervention program, or in lieu of that, for at least 2 days anger management. No alcohol, drugs, or weapons, absolutely no firearms. And we are not asking for a stay away in this case. We would like to sound for Mr. Keenan Webb. I believe he did state he will be on the Zoom today.
All right. Mr. Webb. Do you wish to address the court today? Yes or no? Can't hear you. See the little red microphone to unmute yourself. Can you unmute yourself? Not, I'll have to keep moving. All right, well, if you can't unmute yourself, we can't hear from you. All right, we'll keep going. PD.
Yes, Your Honor, my client is 36 years old. She does have a 2-year-old child. She has been a Georgia resident since 2015. She's graduated from high school, earned a bachelor's degree, and is currently pursuing her master's degree. She's gainfully employed. This is her very first arrest, Your Honor. I spoke with the complaining witness. I have no objection to no violent contact. He is not afraid. He does want contact with her. They have been living together, but he was already planning to get his own place. I think he's moving out, but they are both fine with continuing to live together. It is her apartment, and she's on the lease. Your Honor, she's 36 years old. This is her very first arrest. She's recommended for a signature bond. I understand it's restricted, although I am requesting the lowest surety bond in this case. I don't think that she needs to be monitored by pretrial, especially at level 2, you're taking someone who's 36 years old, has never had an arrest, and essentially it's like she's on probation, making calls twice a month for that. And I object to the family violence intervention or any anger awareness. These are just allegations, and he does not say that he's afraid of her or that he even wanted her to be arrested, Your Honor. And I think that's what he would say if he has the opportunity to speak. So, Your Honor, I'm asking at the most, and I don't know why there's 2 charges on this, so I would ask for the lowest possible surety bond possible on the simple battery family violence, and the battery family violence, maybe a $200 surety bond.
All right, I'm going to order for, and is it Flan or Flan?
Flan.
Flan. For Miss Flan, $500 surety bond, $250 on each. I'm sorry, signature bond through pretrial. I'm sorry, I forgot she has no history.
Well, Your Honor, I think she prefers the 250 on each
Mm-hmm.
Surety bond.
Okay. $500 surety bond, $250 on each. And with that surety bond, no further violent contact with Keenan Webb. And was there a stay away from the Huff Road or not?
No, Your Honor, she lives there and he does want contact.
And
Okay.
we are not asking for a stay away.
Okay. And then no drugs, alcohol, weapons, or guns while on bond. Okay.
Thank you, Your Honor.
All right. Thank you.
Add on position number 2, Bradley.
I'm sorry, which position is next?
Add on to.
Okay. Thank you, sir. I'm on the phone with Mr. Kennedy right now.
Okay. This is 24 CR 008016G. Paul Bradley, charged with 1 count of criminal trespass and damage to property. Pretrial.
The last arrest was August 20th, 2007, out of Dallas, Texas, for aggravated assault with a deadly weapon. They have 10 arrest cycles out of Texas. 2008 felony conviction for possession of controlled substance. Also in 2008, felony conviction for manufacture, delivery of controlled substance, and aggravated assault with a deadly weapon. The recommendation from pretrial is a UJR level 1, nothing further.
Okay. State.
Yes, Your Honor. This incident happened on December 6th of this year. The location of the incident is GE Tower, located at 490 Glen Street, Southwest here in Atlanta. What happened is that a maintenance supervisor at the location found that there was a damaged door for a bathroom. And upon entering the bathroom, they found the defendant inside, and he admitted to the officer that he did not belong on the property. The recommendation is that there be a $1,000 surety bond, and that the defendant stay away from the location of GE Tower at 490 Glen Street in Atlanta.
Okay. All right, PD Atai.
Yes, Your Honor, my client is 50 years old. I did hear that his last arrest was in 2007. That would be 17 years ago. He is recommended for a signature bond at level 1. He does deny the allegations as stated in the warrant, although he has been residentially challenged and states that, I mean, it has been freezing outside, Your Honor. He's been looking for a job, and his car recently was impounded or towed, and he hasn't been able to stay in that as he normally would. I would ask for him, Your Honor, a signature bond through the jail due to the fact that he has not had an arrest in the last 17 years. And Your Honor, he does have a good mailing address.
All right, but of those, prior convictions, did he have one for, in Texas for criminal trespass?
No, Your Honor, no criminal trespass. He's only recently become homeless. And
All
and
right. Go
it
ahead.
was 17 years ago.
Yeah, I will, give him the $1,000, signature bond. And I will do that through the, jail. I will, order that he stay away from GE Tower on Glen Street. Stay away from that location. No drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
All right, thank you.
Position 3, Brooks.
It said it's this add-on 3?
Yes.
24 CR 008017A. This is Napoleon Brooks. 1 count of criminal trespass and damage to property pretrial.
The last arrest was November the 5th, 2024, out of MARTA PD for criminal damage. There's an open case for criminal attempt to commit a felony. That case number is 23 CP 217792. They have a total of 5 arrest cycles out of Georgia. The recommendation from pretrial is a UJR level 3, nothing further.
All right, state.
Your Honor, on December 6, 2024, at the residence of Mary Miller, the location is 1679 Melrose Drive here in Atlanta. Miss Miller came home to discover that the front door of her residence had been kicked in. She was able to access video footage of the incident, and officers were able to confirm that the defendant did, in fact, kick in the door of the residence and then walked off of the porch. The victim and defendant in this case have no relationship and are strangers. And therefore, in light also of the defendant's past criminal history and the fact that he has an open case and a very recent arrest, the state will be asking for a $5,000 surety bond, no alcohol, drugs, weapons, or guns. And we would also stay away from the location of 1679 Melrose Drive in Atlanta. And then we would also like to sound for the victim, Mary Miller, in the case.
All right, Ms. Mary Miller, you're on the Zoom. Mary Miller. I see a Mary Ann's iPhone. Is that her by chance? Mary Miller. All right, we'll
I
keep
don't
going.
believe so, Your Honor.
Is that her? Ms. Miller, can you get your phone off mute and turn on your camera? If you want to address the court, you can. If not, we'll keep moving.
I'm here.
All right, do you wish to address the court today?
No, just that I have footage, my door.
Nope. That's a yes or no. You can't say no and then start talking. Because I'll have to swear you in and I have to see you on the camera in order for you to talk.
Okay, I'm gonna say no.
All right, thank you. All right, PD Atai.
Yes, Your Honor, my client is only 21 years old. He has lived in Georgia all his life. He is currently residentially challenged. He hasn't been able to find a job, but he is searching for work. I think he is recommended for a signature bond or a signature bond at level 3. This is not a bail restricted offense. I would ask for a signature bond through pretrial services at level 3, Your Honor, or a lower surety bond than $5,000. And we have no objection to the stay away, of course.
All right. I'm going to order a $3,000 surety bond. With that $3,000 surety bond, we order that he stay away from 1679 Melrose Drive in Atlanta. You have no further contact with the victim, Mary Miller. Stay away from that location. No drugs, alcohol, weapons, or guns while on bond. And that should be it.
Number 14, Mr. Sharp.
This is 24 CR 008009C, Jonathan Sharp, charge of 1 count of battery, family violence, pretrial.
The last arrest was April the 18th, 2020, out of Union City for battery family violence. That case was DWAP. They have a total of 9 arrest cycles, arrests out of Georgia and Virginia. Felony conviction in 2010 for shooting at or in an occupied building. That was out of Virginia. Misdemeanor conviction in 2009 for credit card fraud. Nothing further to report.
All right. Okay.
Your Honor, this incident took place on December 6, 2024. Officers responded to an Exxon station at 4410 Roosevelt Highway in Atlanta regarding a domestic dispute. Upon arrival, they made contact with 4 occupants of a vehicle, one of whom was the defendant and another of whom was the victim. Initially, they spoke to the defendant, who said that he and the victim, Desiree Banks, were arguing, and she kicked him in the back of the head. The officers then spoke with the victim, Desiree Banks. She denied kicking the defendant in the head and said that the defendant struck her approximately 5 times with a closed fist, and that the other 2 occupants of the vehicle had to physically restrain the defendant so that the victim could escape the vehicle. The victim was seen to have a laceration behind her right ear and also had visible swelling. The officers also spoke to the other 2 occupants of the vehicle, who corroborated what the victim had told police. Your Honor heard about his previous arrest for battery family violence. This was against the same victim, Ms. Banks. And in that case, he was accused of striking her repeatedly with a trash can to the point where the victim left a bloody trail as she tried to escape that assault. That case was dismissed for want of prosecution. The case number is 23 CR 00477C. Nonetheless, Your Honor, this is a documented history of violence between these parties. We have been in touch with Ms. Banks today. She states that the defendant rents a room from her at 7612 Cole Lane in Atlanta. They are not in a relationship. They don't have children. She confirmed the events in the warrant. She stated, she told our advocate that the defendant has been violent with her in the past. She did not want to elaborate on it. However, I just did, Your Honor. That was what happened in the previous case. She would like contact despite all of that and would like for him to be able to return to the residence. And of course, the state's objecting to any contact at this point, Your Honor, given this is the second offense now. And given his history, Judge, we are asking for a $5,000 surety bond, no contact with Ms. Banks, stay away from the residence 7612 Cole Lane. We're also asking the defendant enroll in family violence intervention, no weapons, drugs, or alcohol. And I saw Ms. Banks on the line earlier, Your Honor. If you can sound for her, I believe she's on.
All right, Mrs. Desiree Banks.
Yes.
Desiree Banks,
Yes.
do you wish to address the court today?
Um,
Yes or no?
yes, I do.
All right, hold on a second. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down, but we normally don't allow people on court to have hats on.
I did not hear you.
We don't allow people on the Zoom court to have hats on. Can you take your hat off?
Sure.
Okay.
Velcro, excuse me. Smooth in my hand. Yes, ma'am.
Okay. All right. Are you in fear of Mr. Jonathan Sharp?
I am not.
Okay, do you want to have any further contact with him?
Yes, I help him raise his daughter. I've been in his daughter's life since she's 1.5. She just turned 9 today. And tumultuous, yeah. Arguments, yeah. Jonathan is a beautiful soul. Okay. Whatever he got going on as far as demons, you tend to always hurt the people as close to you. I'm not going to take up for hands put on any woman, but I care for him and his daughter and his mother and the whole family. 9 years I've known him. I do not wish to see him incarcerated. Does he need some counseling, talking? Absolutely. Yeah, but I'm not in fear of my life. Yeah.
Okay. All right. Any cross-examination, State?
No, Your Honor.
Ms. McLeod?
Yes, Your Honor. My client is 37 years old. He is currently unemployed and has been unemployed for several months, so he does not have any money for bond. I'm asking the court to consider giving him a signature bond. It can be at level 2 or 3 so that he can get out of jail. He has a 9-year-old daughter. He tells me his daughter's birthday is going to be tomorrow, and he would like to be there for that event. Nothing further, Your Honor.
Okay. I'm going to order a $2,000 surety bond. With that $2,000 surety bond, and the Cole Lane is Miss Banks's address.
Yes, Your Honor. It's the state's understanding that the defendant also resides there, and we are requesting a stay away.
Yeah, this just happened, so there's not been the ample cooling down period that I would like to see to make sure that this is over with. So right now he'll have to find somewhere to go live. With the 2,000 surety, he is to stay away, and you know, I know that Miss Banks is here stating that she wants to have further contact, but we're doing it to make sure that she will be safe because he has a 2020 and it was DWAP'd, I know, but battery family violence. And that is some significant history there. So $2,000 surety bond, no drugs, alcohol, weapons, or guns while on bond. No further contact with Desiree Banks to stay away from 7617 Cole. Contact your attorney if you need to apply for a modification later. I think that's
Thank you,
it.
Your Honor.
Anything else? Mm-hmm.
And Your Honor, would you consider FVIP at this point?
No,
He's not in a position to pay for it. He's not working.
no. Now that you all can handle that later.
Thank you, Your Honor.
Thank you.
Add on position number 5, Mr. Coleman.
This 24 CR 008019B, Aaron Coleman, charged with 1 count of battery, 2nd count willful obstruction of a law enforcement officer. Pre-trial.
The last arrest was October 26, 2021, out of Fulton County. Out of Fulton County for possession of marijuana. There's a total of 8 arrest cycles with arrests out of Georgia, California, Virginia, and Arizona. 2024 misdemeanor conviction out of Virginia for assault and battery. Nothing further to report.
All right, state.
Yes, Your Honor. On December 5th, 2024, the victim was on a bicycle. He was stopped at the intersection of Wyuka Road and Roxborough. Upon being stopped on his bicycle, the defendant approached and struck the victim in the face with a fist. And this incident, they did not know each other, have no relationship to each other as well. So they were complete strangers. And the request would be based on the defendant's criminal history, a $1,500 surety bond on each charge. Also, for the defendant to take anger management classes and for him to have no alcohol, drug, or guns or weapons.
Okay. State. Oh, you are state. I'm sorry. PDs.
Your Honor, my client denies the allegations in the warrant, Your Honor. He said that he was in the vicinity of Lenox Mall when he was stopped by the police. And the police alleged that he fit the profile of someone who had done something. He denies that he's the person who attacked anyone. That's what he tells me, that it was not him. My client is a resident of Virginia, he tells me, Your Honor. He says he was actually here working. I do not see that he has a significant recent history, unless I did not hear what pretrial said. And he certainly doesn't have a violent history, if I heard correctly. So I would ask.
Go ahead.
I did not hear anything about a violent history. I thought I heard something about drug possession or something like that. I would ask the court to consider giving him a signature bond at maybe level 2 or 3 so he can get out of jail. I have a good address and contact information for him, Your Honor. Nothing further.
I just don't like the fact, I think, and maybe ASG Fawcett would say this, he's a multi-state offender and a Virginia resident. I'm just trying to figure out if he's coming back. Or is he just here temporarily for work?
He is here for work, he tells me, Your Honor.
For how long?
I don't know. He's only been here for 2 weeks, he tells me.
And Your Honor, I would ask also that we sound for Mr. Colin Brown, who's the victim in this case.
Oh, are they on Mr. Brown?
And he may not be on, Your Honor. I just wanted to sound for him in an abundance of caution.
Okay. Mr. Brown? Nope. All right, I will order a $3,000 surety bond, $1,500 on each. No drugs, alcohol, weapons, or guns while on bond. And a stay away from that incident location on Wyuka Road in Roxborough. No further contact with the victim, Mr. Brown. And I guess that'll be all for now.
Thank you, Your Honor.
Mm-hmm.
On number 4.
Judge Missy,
Yes.
I'm not sure if Ms. McLeod is still on the Zoom, but it looks like
I'm still on.
Mr. Coleman has an additional warrant that was added to the jail screen today for a simple battery against a person who is 65 years or older.
Oh,
So he's probably going to have another case for Monday's calendar.
I don't know if you want to talk about it today. You see if we want to handle it today or just wait till Monday. What do you think?
I am here, Your Honor. I don't know anything about that case.
What
Yes,
do we
Your
have,
Honor.
Deputy Falk?
I'm looking at the warrant now. It's a totally different victim than our victim in the current case.
Oh. Okay.
I mean, I can potentially work it up and address it with Ms. McLeod today and send her the warrant if she needs to look at it.
Which Coleman are you guys talking about?
Aaron Coleman.
We took him out. He was getting a little agitated. He acted like he got a little image going on, so we just took him out. So he may have to come back.
Come back Monday.
Then,
Okay.
yep, we're gonna have to come back Monday.
Okay.
Okay.
All right. What do we have before us now?
Add on number 4. Burks the third.
Oh, this is Burks. Okay. 24 CR 00818G. Olin Burks the third. 1 count of simple battery, family violence, and 1 count of criminal trespass. Retrial.
The last arrest was March the 4th, 2014, out of Clayton County for a probation violation. They have a total of 2 arrest cycles in Georgia. Recommendation from pretrial, with the exception of the restricted charge, is a level 2. Nothing further.
All right. State.
Your Honor, on December 6th, at the location of 7855 Cedar Grove Road, in Fairburn, the defendant became involved in an argument with his spouse, who was the victim, Miss Beulah Burks. The victim, once they began to argue, she retreated to the bathroom in the residence to call 911. Once she locked the door of the bathroom, the defendant essentially barged in, damaging the door. And he also, upon entering the bathroom, grabbed the victim and pushed her into the bathtub. The recommendation from the state is that there be no contact with Beulah Burke, at this time, due to there not being a long enough cooling off period. And then also that the defendant undergo the family violence intervention program. And also that the bond amount, will be, our recommendation is $1,500 signature bond on both counts. And finally, we have spoken with the victim, Ms. Burke, in the case. She has told us that both she and the defendant are still residing together. And admittedly, she does want contact, but again, in light of the fact that this incident is still so fresh, we would ask for at this time for there to be no further contact with Ms. Burke. And she may be on the call, Your Honor, so we could sound for Ms. Burke at this time.
All right. Miss Beulah Burks.
Yes, Your Honor.
Okay. Do you wish to address the court today? Yes or no?
Yes.
Hold on a second. Yep. Raise your right hand. Thank you. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down for me. Are you in fear of Mr. Olin Burks III?
No, Your Honor.
And you all are married?
Yes, Your Honor.
Have any children?
No, Your Honor.
And do you want to have further contact with him?
Yes, Your Honor.
And usually I don't do it when it's less than 24 hours because a lot of times, as I've stated earlier, there's not been that cooling down period. And I'm just sending parties back into the same volatile situation. And we want to make sure that you as the victim will be safe. So I don't know what assurances I have that, you know, it's cooled down because it's been less than 24 hours.
May I speak, Your Honor?
Yes.
So during the period of Olin and I, we've never gotten physical, never got into anything. The officers, I literally told him I didn't want to press charges. He didn't have to go, but the officer let me know that the domestic violence is very serious to her. And even two other officers, they were like, he's able to go. It wasn't any domestic violence where he's tried to hurt me. He simply tried to move me out the way, and he was trying to leave because of the heated argument. It wasn't anything. I'm not in danger. It's nothing volatile where it's like 24 hours, you know, we have to spend time apart. It's nothing like that. I feel like the officer kind of escalated. I called 911 wanting him to just leave so that we wouldn't continue to argue, but it wasn't like a fear of danger or, you know, anything like that, if that makes sense. Because they
No,
did.
no, it doesn't make sense to me. If you call 911, that means you have some fear. You call the
Well,
police,
call 911.
someone has a problem.
No,
If you call the police.
I understand, but I simply, it's on the call. I called because I said I want him to leave peacefully. Like, I didn't want to start, you know, anything to bubble. That's why I called. It wasn't a fear of violence for me. And that's the honest truth, Your Honor.
Okay.
And Your Honor,
Mhm.
I'm so sorry, before you rule, I would need to amend the state's recommendation to a surety.
Okay.
And again, we were asking for $1,500 on each count.
All right. Any cross-examination for Miss Burks?
Your Honor, no, I don't have any cross-examination.
Okay.
My client is 38 years old. He has lived in Georgia all his life. His last arrest was 10 years ago in 2014, and I believe that was a traffic matter. He is a high school graduate. He graduated from high school in Georgia. He also attended some college. He is currently working at a hotel in Atlanta. He does have a 14-year-old child. I spoke with the complaining witness, and she stated that she didn't even want him arrested, that nothing happened. The police said, well, you called 911, so he's going to get arrested. I don't think that I don't think that there needs to be any more cooling off period in this case, although a cooling off period is not statutorily required. I think that he was recommended for a UJR at level 2. Again, his last arrest was 10 years ago in 2014. I would object to a FVIP, and I would ask for a signature bond through pretrial services in this case, and no violent contact, as the complaining witness has also requested.
All right, Ms. Burke, have you all had any similar incidents in the past?
Never.
Okay.
Never.
So this
He's
was a
never put his hands on-
one time incident that won't
I
happen
swear.
again?
I swear.
Well, you do, but you know, the
No,
person
I
arrested is
understand.
Mr. Burks at this point.
I
So it's
understand.
not you.
But he's not violent, Your Honor. I'm sorry.
Okay. Well, hopefully if you feel that way again, you'll call the police and they can handle it. But and where was he working again?
Your Honor, he's working at the Waldorf Astoria. He is the Assistant Director of Property Operations.
All right, on the battery family violence, that one would have to be a $1,500 SOB through pretrial. And with that, I'm going to order 2-day anger awareness courses through pretrial. And then the criminal trespass, 1,500 SOB jail with a split bond. No drugs, alcohol, weapons, or guns while on bond. And no further violent contact with the victim, Miss Beulah Burks. So, Mr. Burks, I hope this is over. You all can live peacefully. If not, you'll be back here at Fulton County Jail. And I guess that's it for now.
Thank you, Honor.
Mm-hmm. All right, take care.
Position add-on number 1, Benefield.
This is 24 CR 008015F, D'Amico Benefield, charged with 1 count of criminal trespass, 2nd count of PI. Is this something we can discuss in open court?
Your Honor, I did request a breakout room.
However, Your Honor, the state opposes it unless there is any sort of issues regarding mental health.
I don't know what the facts are for the PI. If it is something that should not be heard in open court, can we hold this to last or not, deputies, or do we know, are the facts that concerning?
We can do them last. We're gonna
Okay.
do position number 9311, Mr. Malik Payne.
Okay. This is 24 CR 007997G, Malik Payne, abandonment of dependent child support. Pretrial.
Oh, and Mr. Payne has 3 cases on the calendar.
Yes, Your Honor, it's positions 9, 10, and 11.
Oh, geez, I didn't see that. Sorry.
Not a
The
problem, Your Honor.
second case is 24 CR 007998G. 1 count of battery family violence, 2nd count of simple battery family violence, 3rd count of cruelty to children in 3rd degree. And the third case, 24 CR 007999G. 1 count of battery family violence and a 2nd count of cruelty to children, 3rd degree. These all relate to the same victims or not?
Different victims, Your Honor.
Oh, okay. I guess we'll start with the first one.
Position 9 will actually be the easiest one. There's a $1,159 purge amount on that case.
All right. And that's what has to be paid to clear that out. That's the purge amount. Nothing else to discuss on that.
I'm sorry, what's the purge amount?
$1,159.
All right. Pretrial, let's have his history, please.
All right, the last arrest was August 31st, 2023 out of Fulton County for aggravated assault and possession of a firearm. The case is open under 23 SC 191847. There's a total of 7 arrest cycles in Georgia. There's another open case. This one is for robbery. That case number is 23 SC 191891. There's a felony conviction from 2020 for aggravated assault and possession of a firearm during the commission of a felony. The recommendation, with the exception of the restricted charges, is a level 3, nothing further.
All right. State.
Yes, Your Honor. Starting with case 20, position number 10. On that case, Your Honor, the incident that happened was on March 7th of 2024. Miss Indira Hill stated she was on the phone inside the home of the defendant, who is the father of her child, SH. The defendant did not want her taking pictures of him, and she denied him access to her phone. The defendant then snatched the phone from her hands, and she tried to leave with their son, SH. As she tried to exit the residence, the defendant grabbed her, pulled her down the stairs, and while she was holding their son, and then bit her on the right hand, which caused a laceration that was observable to the officers, and drug her and her son outside and threw their items outside with them. Upon looking through her items, she realized that $100 was missing from inside of her items. We had an opportunity to speak with Miss Indira Hill. She stated that they are not in a relationship, they do not live together, and the defendant and her share one child. She did confirm the events in the warrants. She said that the child was present and witnessed the incident. And notably, she is the same victim on 23 SC 191891. That case is currently on judicial hold because the defendant failed to appear in court, and that was charges of robbery, family violence battery, cruelty to children in the third degree, and battery. A bond of $7,500 was issued on September 1st of 2022 on that case, with an order to have no weapons, no further violent contact with Indira Hill, and no further violent contact in the presence of Samir Hill. All conditions of the bond that he has now violated. In that previous case, the defendant allegedly snatched Miss Hill's iPhone, struck her in the face, resulting in swelling to her eye and lip, and did so in front of the child, SH. The victim did state when she spoke with us that she filed for a TPO on October 10th, but it was dismissed. We were able to confirm that. And she stated she wants no further contact with the defendant and wants him to stay away from her residence at 1754 Richmond Circle Southeast in Atlanta, Georgia. I will point out that the defendant has a $7,500 surety bond for drugs and driving offenses in the jail, as well as a current pending warrant for aggravated assault and cruelty to child on the third degree, dating July 27th of 2024, involving the second victim, which we'll get to, Miss Jalen Wynn. The defendant has 10 cycles. Again, as you've heard, he has a judicial hold for an aggravated assault, a judicial hold for a robbery, family violence battery, cruelty to children, and battery, both for failing to appear. And he's on first offender conviction for 18 SC 157050 for aggravated assault, possession of a firearm during commission of a felony, where he received 10 years with 5 years suspended on October 2nd, 2020 in front of Judge Richardson. He currently has no bond on that case for a probation violation warrant that he has to address in the court on December 7th of 2024. Basically, and this is the most polite way I can put it, this person is just an absolute hot mess when it comes to criminal offenses. He has offenses, number of offenses involving violence, a number of offenses involving violence to women. He has probation violations open, FTAs. If there is an Ayala factor, he has managed to violate it. So on this particular case, which is the case ending in 7998G, we are asking for a $10,000 cash bond. We are asking that that be broken down as follows: $6,000 on the family violence battery, $1,500 on the simple battery family violence, and $2,500 on the cruelty to children in the third degree. We're asking for no further contact with Indira Hill, stay away, and also no further contact with SH, the minor child. Stay away from the address that we previously stated, which was 1754 Richmond Circle Southeast in Atlanta, Georgia. No alcohol, drugs, or weapons, and absolutely no firearms. We are also asking for family violence intervention program. We would like to, at this time, sound for Indira Hill if she is here in the court and would like to speak.
Indira Hill. Indira Hill. All right, keep going. P.D. Bronstein.
Yes, Your Honor. First of all, I want to, before I talk about Mr. Payne, more in depth. I do want to point out that for the case in March that allegedly occurred with Ms. Hill, he tells me that he was out of state for work from February till July and returned in July, and that he has proof of that. So we very much need to look into that, because if he was in New Mexico, there's absolutely no way he could have been here. So I just wanted to put that out there, because the state made a lot of accusations, including calling Mr. Payne a hot mess, which I've never heard uttered in court before. That was new. So I just want to point out that he is presumed to be innocent, and we do need to look at these charges and the facts surrounding them. Mr. Payne is 29 years old. He is originally from Chicago, but has lived in Georgia for a very long time. Even his family is here. His brother and sister actually live nearby him. He moved here for work. He works in the film industry. That's why he was in New Mexico for a few months. He was working on a film, but he's now back in Atlanta. Does have some college. He has ties to the community. As I said, we really do need to look into the facts of these cases. And I would ask that the court take that into consideration.
Okay. All right, I'm very concerned about what I've heard. I don't know how I could look more into them or to consider it. Let's see.
I mean, if he's out of state, he's out of state, and we need to verify that.
Are you saying
Hey, this is
factually?
Indira. I have proof that I was there.
Excuse me, do not interrupt me. And you're saying, he wasn't in town when it happened? Is that what you're telling me as a defense or an alibi?
He says that he was in New Mexico working on a film, and that he has proof.
Well, I don't know about that. That would be
And you're-
something that would have to come later, but
Yeah, and Your Honor, if he has proof of that, that can be addressed at a bond modification hearing on the SAP calendar in 2 weeks.
right.
And proof is very difficult to get when someone is in custody.
What, a bond modification hearing?
Well, it's much more difficult for us to get things than for our clients to get things, especially with passwords and things like that. But I just wanted the court to take that into consideration.
All right, I think the victim is on the line. Miss Hill. Indira Hill. Miss Hill. Well, I'm gonna sound for you one more time and I'm gonna move on. Indira Hill. All right. I'm gonna go ahead and give my ruling. And I am going to order that $10,000 cash bond, $6,000 on the battery, $1,500 on the simple battery, $2,500 on the cruelty to children. And with that cash bond, no drugs, alcohol, guns, or weapons while on bond. When you violate the other bonds, we don't play with that. And that's why there is the cash bond. No further contact with the victim, Indira Hill. Stay away from 1754 Richmond Circle Southeast. And again, no drugs, alcohol, weapons, or guns while on bond. Next case.
Your Honor, the next case again involves Mr. Payne. This case was from July 30th of 2024. In this case, the defendant is alleged to have Miss Jalen Wynn stated she was in a verbal dispute with the defendant, the father of her child. He began beating her because he was upset that she left the child at home and went for a walk. Miss Wynn had an injury to her lower lip that was observable by the officers, and the incident occurred in front of SP, their 1-year-old child. As I have explained, Your Honor, the defendant also is currently pending on no bond for aggravated assault and cruelty to a child in the third degree on July 27th of 2024, 3 days prior to this incident, which involves allegations that he strangled Jalen Wynn in front of their minor child, SP. You've already heard the defendant's extensive and violent history, as well as the fact that he has multiple FTAs in cases pending before the Superior Court. We did have an opportunity to speak with Miss Jalen Wynn. She stated that she and the defendant are in a relationship. They no longer live together and they do share a child. She confirmed the events in the warrant when the victim advocate spoke with her, and she stated that neither of them currently live at the incident location. She also acknowledged the felony case that allegedly happened 3 days prior to this case. She said that prior to this, he had never been violent with her in the past, and that they have been in contact since this incident and there has not been violence since. She does want contact. However, given the circumstances and this defendant's extensive and violent history, we do object to contact. She should be here on Zoom, so we would like to sound for Miss Jalen Wynn. As far as Miss Wynn, the state is asking for a $6,000 cash bond. That would be $5,000 on the battery and $1,000 on the cruelty to children in the third degree, as well as conditions of stay away from any residence of Jalen Wynn and no further contact with Jalen Wynn or the minor child SP, no alcohol, drugs, or weapons, and especially no firearms. We would at this time like to sound for Jalen Wynn, and that's all for the state.
All right, Jalen Wynn.
Yes, hi.
Hi, do you wish to address the court today, yes or no?
Yes.
All right, this is not a trial. This is a bond hearing, so it's very limited to what I can hear or will hear today. I have 2 questions for you. Raise your right hand for me. Yeah. Do you affirm that the testimony you're about to give is the truth and nothing but truth under the penalty of perjury?
Yes, ma'am.
Do you have the child sitting there in your lap listening to us?
Yes, ma'am.
How old is the child?
She's 1.
I generally don't like that because, believe it or not, they're little tape recorders. Hopefully we won't say anything that will be disturbing or something that the child should not hear, but I guess you can't. Looks like you're in a car, so you can't go somewhere and put the child up and then come back.
Yes, ma'am.
You can or can't?
I can't. No, ma'am, I cannot.
Okay. All right. Are you in fear of Mr. Malik Payne?
No, ma'am, I am not.
You want to still have contact with him?
Yes, ma'am, I do.
Are you all living together?
Not at the moment, we are not, but we are currently in a relationship, yes.
Okay. And so, looks like this incident happened back in July.
Yes, ma'am.
Okay. And you've been living together since then?
No, ma'am.
Oh, you have not? Okay.
No, ma'am.
And are you living together now at the present? No.
No, we are not living together right now. We decided to still be together, but separate ourselves to help us get better with our anger and our depression. So that's something we've been working on, going into therapy. So that's things that we've been trying to figure out ever since that incident. Yes.
All right. Any cross-examination by the state?
Miss Wynn, just to ask you, did you call the police on the date of July 30th, 2024 when this incident happened?
I'm not sure. I know the neighbors called the police.
Okay. What about the previous incident on July 27th of 2024?
Yes, I did.
Okay. Why did you call the police on July 27th of 2024?
Because we had got into a heated argument.
An argument that resulted in him allegedly strangling you, is that correct?
Yes, both of us was doing things that we shouldn't have been doing. Yes, I was intoxicated, but I didn't tell nobody that. So not even the police.
Okay. That's all, Your Honor, for Mrs. Wynn. Thank you, Mrs. Wynn.
You're welcome.
I do have one question.
Yes.
Ms. Wynn, has there been any violence since July?
No.
No further questions from the defense.
I do have one additional question.
Right.
And Ms. Wynn, when did you and Mr. Payne stop living together?
Like a few months ago.
Like around August after this happened?
No, like the end of August, sometime in September.
Okay. That's all for Miss Nguyen, Your Honor.
All right. PD?
Thank you, Your Honor. As Ms. Nguyen pointed out, there has been no violence for the past several months. They are still together, just not living together. It sounds like they are doing therapy, and I believe that would be very helpful to them and very helpful to Mr. Payne. Also, I want to point out one thing that the state said earlier. They focus so much on all these judicial hold cases. And I know everyone here knows this. I just want to state for the record, as we are all aware, a case is only put in judicial hold if it is not verified that the person did get notice. Otherwise, obviously, there would be a bench warrant. So I feel like putting it in the same category as someone getting a bench warrant is a little bit disingenuous from the state. And I would ask the court to take that into consideration and to do a surety bond instead of a cash bond, with whatever conditions the court deems appropriate.
All right, I'm going to change this to a $15,000 surety bond, and that will be 14,000 surety on the battery and 1,000 surety on the on the cruelty to children, for a total of 15,000 surety. No drugs, alcohol, weapons, or guns while on bond. And I'm trying to decide with his history, and although it's been a few months, I don't know that it's been that long. I'm going to still order at this point that there be a stay away from the home and work location of Jalen Nguyen, and that there be no further contact right now with Miss Nguyen and the minor SB. And we'll see where this is going and to make sure that they're going to be safe.
And Your
That's
Honor,
it.
my apologies. It's SP as in Peter. I may have misspoken.
P instead of B. Okay. All right. And that's it.
Thank you, Your Honor.
Station 12, Peterson.
Your Honor, the state has an announcement on this case. The state's actually moving to null pros this matter. I'll submit the null pros here momentarily. The defendant was on felony first appearance this morning, and this charge is part of the underlying felony. He already has a bond on it. There was a little bit of confusion because there are two different victims, but the incident from the felony happened on the same day as this case, and they are related. So initially this morning, we thought they were going to be separate cases. We learned after court started today that they're actually going to be one case. And I have looked at the bond order from the felony case, and this charge was included in the felony matter. So we are moving to null pros.
And I'm sorry, which case is that?
Position number 12, Carlos Peterson.
That's what I thought.
It'll be null pros. Okay. All right.
Position number 15, Mr. Small.
Okay. This is 24 CR 00801 OG, Anthony Small, charge of 1 count of theft of services. Pre-trial.
The last arrest was September 7th, 2024, out of Burbank, California for theft of services. They have a total of 8 arrest cycles with arrests out of Georgia, California, and Texas. There is an open case for theft of services, 24 CR 001975G, and then an open case for battery family violence, 24 CR 001977G. There also appears to be a hold out of Houston, Texas for an FTA on a theft case, and the date of that warrant is April 8th, 2024. The recommendation from pretrial is a UJR level 2, nothing further.
Okay.
And Judge, this incident took place on December 6th at the Pasha Restaurant and Bar, Pasha. Incident location is 631 Miami Circle. This happened about 3 a.m. When officers arrived, they spoke to management at the location, who stated the defendant was there eating and drinking for most of the evening. He got a tab of roughly $195. And when it came time to pay his tab, he could not. By the time the police arrived, the management had been essentially waiting for the defendant to pay his tab for over 2 hours. So when the officer approached the defendant and asked if he was able to pay his tab, the defendant asked the officer for 30 more minutes to try to get the tab paid. And the officer initially did give him some time. However, after a few minutes, it became clear that the defendant was not making any effort to try to pay his tab. He was scrolling on Instagram. And so at that point, he was placed under arrest. You heard from pretrial that this defendant has an extensive theft history, including his open cases in state court here. His theft of services case that is currently open, Your Honor, and his open battery family violence case, they're both in bench warrant status from failure to appear. Sounds like he also has holds from failure to appear in other states. There's risk of reoffense here. He's in violation of both of his bond orders from the cases that he has open in state court now. And I'd also like to add that these theft of services cases are at restaurants and bars. The open case is at a cigar lounge. This is not a situation where someone is unable to eat and going in to sustain themselves. This is someone who's going out and partying and racking up high tabs and then having no regard and no intention to pay for it. So at this point, Judge, given that he's in violation of both of his bonds that are currently for his cases that are in state court now, and they're both in bench warrant status, we are requesting a $5,000 surety bond, a stay away from the Pasha Restaurant and Bar, and no weapons, drugs, or alcohol.
All right. PD Bronstein.
You're muted, Ms. Bronstein.
Thank you. Sorry, I muted myself when, yeah. So I do want to start off by discussing some biographical information about Mr. Small. He is 35 years old. He is from Riverdale, Georgia. He grew up here. He did move out west a little bit ago for work, but his family still all lives here. Father, sister, cousins, his family all lives here. He does work for DistroKid Inc. He works under the Spotify division that's in the entertainment industry and has worked there for 8 years. As far as this case goes, he did tell me that when he tried to pay with his card, there was a fraud alert. He needed to go to the ATM to try to get cash. He asked the establishment if he was able to go get cash. They did not want to allow him to leave. He said he can pay it. He needs to go get cash because he was not able to deal with the fraud alert at that time when tried to pay with his card. As far as the case that appears to be in bench warrant status, he did say that he calls that he's on pretrial calls and emails his pretrial officer, Ms. Tristan, every month and ask for updates. So I would need to get in touch with her to figure out what's going on with that. When I looked at this case earlier, it appeared in Odyssey that a $1,500 bond surety bond was already set. I would ask that the court not set a bond that exceeds that.
I'm going to order the $5,000 surety bond. He's a multi-state offender, open cases, holds, a lot going on there. Stay away from the Pasha restaurant. And no drugs, alcohol, weapons, or guns while on bond. I think that's it. Anything else?
Nothing for the state, Your Honor.
Position number 17, Jamel.
This is 24 CR 008011Y. Christopher, is it Trammell or Trammell? One count of simple battery, second count of criminal trespass. Pre-trial?
One moment, Your Honor.
Hmm?
That history has been left off. Bear with me one moment while I generate it quickly.
You want the state to give it?
I have it, Your Honor.
Okay, we'll let the state do it.
Thank you.
Uh-huh.
Your Honor, he has 57 cycles. His most recent conviction was August 13th of 2024 for disorderly conduct and criminal trespass in Clayton County. His last arrest was in 2022 for a probation violation. He has arrests from several arrests for the last several years: 2021 theft by shoplifting, and 2020 theft of lost and mislaid property, several arrests for criminal trespass in various counties and at the Georgia Tech campus. He has a felony matter of tampering with evidence. He has several prior shoplifting convictions, criminal trespass convictions, willful obstruction, theft by taking. This incident took place at the West End MARTA station bus loop on December 5th. The victim is Shanalivia Barber. I apologize if I'm mispronouncing that. She told police that the defendant approached her and slapped her across the face. After the defendant was detained, it was discovered that he did have an active MARTA suspension that is valid through the end of July 2025. We have been in touch with Ms. Barber today. She states that she and the defendant know each other from when they were younger, but they're not close friends. She states that she sees him from time to time and would say hello. On the incident date, he saw her at the MARTA station. He approached her and grabbed her arm. She asked him to stop, and he started acting aggressively towards her as if he wanted to fight her. And she says the next thing she knows, he slapped her in the face. She wants no contact, and if Your Honor can sound for her at the appropriate time. Given his criminal history, Your Honor, the state's requesting a $2,000 surety bond. That's $1,000 on each count. No contact with Ms. Barber. Stay away from all MARTA in accordance with his active suspension, and no weapons, drugs, or alcohol.
All right. State. I'm sorry, PD.
Thank you, Your Honor. Mr. Trammell is 43 years old. He was born and raised in Atlanta. He does have some health issues and is residentially challenged. However, he does have a stable mailing address that he can check regularly and would not miss a court notice. He said that he and Ms. Barber did grow up together. He stated to me that he did not hit her. They were joking around. It was not his intention to hit her or cause her any harm. He does not have any money to be able to bond out. As I said, he is transient, does not have stable housing. But again, he does have many ties to the community, born from here, has lived here his entire life, and does have a stable mailing address. We are asking the court for a signature bond in this case.
No signature bond with 57 cycles. I will order the $2,000 surety bond, 1,000 on each charge. Stay away from all MARTA. He's on an active suspension anyway. No drugs, alcohol, weapons, or guns while on bond.
And Your Honor, we requested no contact with Miss Barber as well.
Oh, and also, so I'm sorry, no further contact with Miss Barber. And that should be it.
Position number 18, Weeks.
This is 24 CR 008012H, Shane Weeks. Charge 1 count of willful obstruction of a law enforcement officer, 1 count of driving, speeding, 3rd count of driving following too close. Pretrial.
This defendant doesn't have any history to report at this time, and with the exception of the restricted charges recommended for a UJR through the jail, nothing further.
Okay.
Your Honor, this incident happened on September 13th, 2024. The defendant was pulled over on I-20 eastbound at the Boulevard exit for speeding, going 80 miles per hour in a 60 mile per hour zone. And he was also cited for following too closely. The officer brought him the citations. He refused to sign them and also refused to even accept them from the officer. In candor, Your Honor, we don't have a ton of information on this case yet, but presumably he drove off and that's why he wasn't initially arrested. We're requesting, it's his first arrest, but this is a restricted charge because of the obstruction, Your Honor. So we're requesting an SOB through pretrial services, no weapons, drugs, or alcohol.
All right. PD Bronstein.
Yes, Your Honor. Signature bond through pretrial is fine to give the court a little more information. He is 45 years old. He lives here in Atlanta, has lived here for about 2 decades now. He moved here with his son and his mom, and he has a 21-year-old son and he has 7-year-old twins. The facts, we really definitely want to see the video because that's not at all what he said happened. Also, he did go to court for Atlanta City Court for this case. And he just went to court. That's when he found out that there was an open case or open warrant. He had no idea. He knew about the ticket. He showed up to court for it, turned himself into the police station. That's why he's here. Absolutely no risk, flight risk or anything like that. He said that the officer asked why he was speeding. He didn't want to respond. Officer took his ID, and that the exchange about the refusing to sign a ticket didn't happen. Again, we need to see the body cam. So, no objection to your signature bond. So that we can iron all this out.
All right. On the first charge, the willful obstruction, 1,500 SOB through pretrial. And on the 2 driving offenses, 1,000 each and 2,000 SOB jail. So it's a split bond of 3,500, 1,500 SOB pretrial on the obstruction and 2,000 SOB jail on the other 2 driving charges. No drugs, alcohol, weapons, or guns while on bond. That should be it.
Number 7, Kennedy.
Okay.
And for Kennedy, I asked for a breakout.
The MH?
Yes, Your Honor.
And then who else do we have left? Oh, Benefield.
Yes, position number one on the add-on.
All right, Mr.
And
Jordan.
position number 6, that was a waiver, correct?
Oh,
Yes.
and we have the waiver, sorry, yeah.
Yes.
We have those two. So Jordan, you want to put us in a breakout?
And if Miss Fawcett could come into the breakout as well.
Is Mr. Kennedy in the courtroom?
Yes, sir.
Yes, you right here?
Okay, thank you.
All right. And is this Mr. Kennedy?
Yes, it is.
Okay. All right, we're trying to sound to see if the victim, Miss Renee Atkinson, is on the Zoom. Renee Atkinson? No? All right, go ahead, state with your recommendation.
Your Honor, the state's recommendation due to the current FTA pending for this defendant, the 11 cycles out of Alabama, the multi-state offender with a 2019 aggravated assault out of Louisiana, as well as 11 cycles in Georgia, and a recent arrest of aggravated assault in the third degree in May of 2022 in Alabama, due to the repeat history as well as the danger to this victim. We are asking for a $10,000 surety bond, no further contact with Renee Atkinson, stay away from 3787 MLK Junior Drive in Atlanta, that we are agreeable to having a police escort to determine whether Ms. Atkinson has vacated that location or no longer or does not reside at that location, at which point the defendant may resume living at that location if she does not reside there. No alcohol, drugs, or weapons, and family violence intervention program.
Okay.
And that division, Your Honor, would be $7,500 for the battery, $2,500 for the simple battery.
All right, Ms. Bernstein?
Thank you, Your Honor. And based
Or
on
Bronstein, I'm sorry.
I respond to anything that kind of sounds like my last name. So based on the all of the health concerns that we relayed, the fact that this is a few months old and nothing appears to have happened since, the fact that he currently is getting outpatient treatment and has a very limited fixed income, we are asking that the court do a signature bond or a lower bond if the court's not inclined to do a signature bond. Also, again, for the record, Mr. Kennedy expressed to me that that is his address, that she no longer lives there.
Okay. All right, based on what I've heard, I'm gonna order the $10,000 surety bond, $7,500 on the battery, $2,500 on the simple battery. No further contact with the victim, Renee Atkinson. Stay away from 3787 MLK Drive. However, he can arrange for a one-time police escort to go back to that location when they sweep the location. If they determine that there are no belongings or things there that belong to Ms. Atkinson, then the defendant may stay there. If she still has belongings there, or it appears she may be living there, the police will make that determination and not allow him to stay. Then he would just get some personal belongings and go stay somewhere else until we do a bond modification. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it for now. Did I leave out anything?
Nope.
Nope.
That's all, Your Honor.
All right. You're gonna ask your attorney later, Mr. Kennedy. Unless it's a question about the bond conditions, but I don't know if the attorney's gonna want you to speak or ask a question or not.
Mr. Payne, I'm going to let my supervisor know that you want to speak with an attorney from my office as soon as possible, okay? Okay, do you have a question about the?
Yeah. No, I mean, first of all, ma'am, it is my house.
So that is what I told the court. Basically, for the police escort, I misunderstood when Ms. Falk first said that as well. Basically, it's just the police verify that it's your house, that she doesn't live there, then it's fine.
And also, ma'am, I get this woman $1,000 to get a car. She come moves in with me.
Don't want to hear the facts. This is not your court date for the trial. That's not going to be relevant at this point.
And Mr. Kennedy, we already, as I said to you before, that we discuss things with the court, so that the court is aware.
I need to go back to the hospital. I can't. They cannot pursue my heart and stuff. They don't have facility for me here. You know what I mean? For heart monitor, breathing monitor, they don't have none of that stuff here.
And Mr. Kennedy, I also relayed that to the court as well.
All right.
Can we go back to add-on number one, Mr. Dennisfield?
Okay.
And Ms. Fawcett, if you could just check your chat.
This is Benefield D'Amico, 24 CR 008015F. Charged with 1 count of criminal trespass, 1 count of public indecency. Mr. Jordan, can you turn off the live stream?